So good afternoon, and thank you for coming to our inaugural fair housing training in Buncombe County. I'm really excited to be offering this program along with our other partners, the City of Asheville and Land of Sky, Council of Government. It's really nice to have come together to partner. Land of Sky covers 4 counties, including Transylvania, Henderson, Buncombe, and Madison. So hopefully we've got people from all 4 counties. This morning's session was really focused on HUD grantees with CDBG or home funds. This afternoon one will be more general and also probably more focused on issues for tenants and landlords. So what are those situations you run into? Couple housekeeping things. Please make sure your phone is off and or on vibrate so that doesn't disrupt us. The bathrooms are straight up of this hall right behind us if you need that, and there's also a water bottle filler, which still to this day excites me that somebody created those. So take advantage of having that, this nice new facility that the city is offering us to use. And so thank you for that piece. Let me do an introduction for our Fair Housing Project partners from North Carolina, Legal Aid, that will be with us and presenting this information today. So Lauren Brazil is the co-director and managing attorney for Legal Aid of North Carolina, Fair Housing Project. And she has represented victims of housing discrimination across the state in fair housing administrative proceedings before the U.S. Department of Housing and Urban Development, also known as HUD, and the state and local administrative agencies, as well as in state and federal courts. She's presented at fair housing seminars for housing consumers, advocates, attorneys, and housing providers. She's got a wealth of knowledge, and we really appreciate having that here today. She's a heritage Spanish speaker and has worked with Spanish-speaking clients and communities across North Carolina. And on that note, we're looking forward to offering a Spanish version in the fall, and hopefully more trainings as well. So this is hopefully going to be something that we'll be able to at least do annually, if not more often. And Hope Williams, who's also from NC Legal Aid Fair Housing Project, is a supervising attorney, and she represents victims of housing discrimination across the state. She's worked at Legal Aid since 2006 and previously was a staff attorney at Texas Rio Grande Legal Aid. Before joining the Fair Housing Project, Hope handled special education cases for students in public schools and immigration cases for victims of domestic violence and trafficking. She spent several years at Legal Aid's centralized intake unit, where she advised clients in a wide range of civil law matters and supervised Legal Aid's fair housing intake and advice cases. She graduated from the University of Texas School of Law, got her undergraduate in history at the University of North Carolina at Chapel Hill. So thank you very much for being here, bringing an in-person training. Please be thinking of your questions. We'll have a Q&A session at the end. And please, if you've got a question, ask it. I guarantee you aren't the only one thinking it, and somebody else in the audience will be very thankful that you got up and asked it. So, further ado, we'll let Lauren take it away.
Thank you so much, and good afternoon, everyone. Good afternoon, all right. Everyone's had some coffee after lunch. Let's wake up a little bit. So my name is Lauren Brazil. I am a co-director and a managing attorney of Legal Aid of North Carolina's Fair Housing Project. Legal Aid of North Carolina is a statewide nonprofit law firm. We represent individuals that assist people in all 100 counties. The Fair Housing Project is a statewide access to justice project. We are based in Durham, but we assist North Carolinians across the state with fair housing issues, and we are funded by the U.S. Department of Housing and Urban Development. That allows us to come and do community education as well. And so thank you to you all for being here, and Buncombe County and the city of Asheville and Land of Sky for organizing today's training. The training, because I'm a lawyer, I have to give this disclosure, right? It's for informational purposes only. It's not legal advice. We do encourage questions. I ask that you try to keep them general in nature. If you are facing housing discrimination, or if you have a specific question about someone you are working with or assisting, let's talk offline and in a confidential setting where we can really discuss your issues. So please keep your questions general in nature. We're going to do an overview of the Federal Fair Housing Act, and then we'll dig in a little bit more into protections for people with disabilities, reasonable accommodations and modifications, and then we'll talk about protections for justice-involved individuals and tenant screening and criminal background screening. So we're going to cover a lot of material today, but we hope you learned something new at the end of the training. Is this your first fair housing training? Raise your hand. Okay, this is great. Excellent. Okay, so we're going to start with an introduction to fair housing laws. And I think it's important to start with, well, when might we see fair housing issues come up, particularly in the tenant context? So we've got a few scenarios that we'll just walk through, and I want you to keep these in mind as we go through the materials. So a tenant applies for an apartment, and he's told he qualifies, and then he meets the property manager, and he's told that the property was already rented. And it's when the property manager sees and meets the person and sees that he's Black. Okay, that would be an example of housing discrimination. A tenant who uses a wheelchair is told that she's going to have to pay an extra deposit because the wheelchairs damage walls and floors, right? That would be a form of housing discrimination. A tenant is told that the landlord won't file for eviction if she has sex with him. Sex harassment is sex discrimination under the Fair Housing Act. We receive complaints of sex harassment from housing providers every year, from the mountains to the coast. It is sadly a prevalent problem. A tenant couple who's about to have a baby are told that they no longer qualify for a one-bedroom apartment, that they're going to have to move into a two-bedroom apartment once that baby is born. It could potentially be a form of housing discrimination. A tenant is denied a reasonable accommodation to have an assistance animal, a service animal, or emotional support animal in their unit because the apartment complex does not allow pets. Could be a form of housing discrimination. A tenant who is a survivor of domestic violence is told she doesn't qualify for an apartment because a prior landlord reported that the police were often called to the unit. The new landlord says this shows that she will disturb the quiet enjoyment of other residents. Could potentially be a form of housing discrimination, right? So think about these types of scenarios as we walk through the materials today. When we're talking about fair housing, we're actually pulling rights and responsibilities from a few different sources of law. The primary law is the Federal Fair Housing Act, and that is the bulk of the material that we will cover today. We will mention other areas, other sources of law, but the primary law is the Federal Fair Housing Act. The state of North Carolina has a state Fair Housing Act that is substantially equivalent to the federal act. And what that really means is that there is a state agency in North Carolina, the North Carolina Human Relations Commission, that is authorized by HUD to accept complaints of housing discrimination, investigate those complaints, and try to resolve them. The Americans with Disabilities Act provides additional protections for people with disabilities in the areas of public accommodation. Oftentimes when we think of public accommodation, we are thinking of movie theaters, grocery stores, public buildings, right? But in the housing context, that can apply to the leasing office and the public and common use areas of the property. Section 504 of the Rehabilitation Act provides, again, additional protections for people with disabilities. Where we see it really come into play is with physical modifications to a unit to make it accessible for a person with a disability. When it's subsidized housing, Section 504 requires the housing provider to make those modifications to the unit. It's a unique part of the law. And then there are also physical accessibility requirements in the state and local building codes. But again, the primary law where we see fair housing rights and responsibilities, and the law that we're going to focus on today, is the Federal Fair Housing Act. And so we're going to do an overview of what the Federal Fair Housing Act is. So the Federal Fair Housing Act prohibits discrimination in housing because of a person's membership in a protected class. And we're going to break down each one of those terms during today's presentation. So when we talk about, well, where does the Fair Housing Act apply, right? So the term that the law uses is dwelling. Well, what's a dwelling, right? So it will really include almost any residential unit that's available for sale or rental. So houses, apartments, condominiums, group homes, shelters, migrant housing, assisted living, long-term transient housing, vacant land where housing can be built, is all subject to the Fair Housing Act. It applies to subsidized housing as well as private housing. There are a few limited exceptions to the coverage of the Fair Housing Act, and then there are exceptions to those exceptions. It's just the way the law works. But one of the exceptions that you might see, or that we sometimes see, is when it's called the Mrs. Murphy exception. Mrs. Murphy was a little old lady who owned a small apartment building. It was like a duplex, right? So Ms. Murphy lives on one side of the duplex and rents out the other side of the duplex. Ms. Murphy is exempt from certain parts of the Fair Housing Act. In that, the Ms. Murphy exception is up to 4 units in that single building, and the owner has to live in one of those units to be exempt from certain parts of the Fair Housing Act. Ms. Murphy is still prohibited from making discriminatory statements. But there's some exceptions, again, limited. And so if there's a housing provider that's telling you, I'm not subject to the Fair Housing Act, I don't have to comply with that law, I would encourage you to contact someone who has real expertise in the fair housing area to see whether or not that is correct. Who has to comply? Well, almost anyone that's involved with the operation of housing will have to follow the Fair Housing Act, and that includes all the various names that we give to people, like whether it's the owner, or the landlord, or the management company, or the manager, the maintenance staff and their other employees, real estate agencies and their agents, insurance companies, lenders, banks, homeowners associations and condo boards. We receive a lot of complaints every year involving homeowners associations, particularly related to reasonable accommodations and modifications that people need to their housing that oftentimes requires HOA approval. That we receive a lot of complaints related to HOAs and condo boards who are made up of volunteer homeowners and may not realize that they are subject to the Fair Housing Act, but they are. Neighbors and other third parties can also be subject to the Fair Housing Act. We had a case out of the Eastern District of North Carolina involving tenant-on-tenant harassment. When the housing provider knew of the harassment, failed to take action to stop the harassment, and they had the authority to do so, they were held liable for the tenant-on-tenant harassment against our clients. So the Fair Housing Act, right, and you may be getting this from where I'm talking, it's broad. It is a remedial statute designed to correct past wrong, right? And it is broadly applied and broadly interpreted. So there are 7 protected classes under the Federal Fair Housing Act. The Federal Fair Housing Act was initially passed in April of 1968, 7 days after the assassination of Dr. King. When it was originally passed, there were 4 protected classes. Race protects all races. Color of skin, what we generally think of it as color of skin within a particular racial group. So someone is being treated differently because of the color of their skin. So if they are a dark-skinned Latino or a light-skinned African American, particular to color of skin. Now you can also see how you might have some overlap between race, color, and national origin. You aren't limited to one protected class. You can be a member of more than one protected class. Most people are. So there's race, color, national origin was part of the original protected groups, generally thought of as ancestry, place of birth, country of origin, but remember that someone's national origin could be identified in a variety of ways. If someone speaks another language, or if someone speaks English with an accent, it could indicate to a housing provider that they are of a different national origin. Religion protects all religions, protects someone's right not to practice religion, and so those were the original 4 protected classes. In 1974, sex was added as a protected class. It was originally added as part of financial discrimination and pregnancy discrimination against women, but since then, through case law and regulations, we understand that sex discrimination is much broader than that. And so under the Fair Housing Act, sex harassment in housing is a form of sex discrimination. There are 2 forms of sex harassment in housing. The first is quid pro quo, this for that. Oh, you're late on your rent? Well, I won't file for eviction in exchange for sex. The offer from the housing provider is the violation of the fair housing laws. It does not matter whether or not the person acquiesces to the offer. The law is violated when the offer is made by the housing provider. This for that, quid pro quo. The other form of sex harassment under the Fair Housing Act is what we call a hostile housing environment. You can have a situation where you have a single egregious act that can constitute a hostile housing environment, but generally we are looking at the totality of the circumstances, and we see more than one incident generally. The Fair Housing Act sex category also prohibits discrimination because of sexual orientation and gender identity. And then the last part that we will talk about, that I hope we'll talk about more today, are the protections, the fair housing protections for survivors of domestic violence, because survivors of domestic violence, both nationally and in North Carolina, are disproportionately women. And so housing providers that refuse to rent to a survivor of domestic violence or evict a survivor of domestic violence because of the violence perpetrated against them could be violating North Carolina general statutes as well as the Fair Housing Act. We'll talk about more of that today. Familial status prohibits discrimination against families with children under the age of 18. This is a really unique part of our fair housing laws. There's 2 areas where we see generally complaints revolving around familial status discrimination. The first has to do with occupancy restrictions, right? Some housing providers will just have a blanket policy that just says 2 people per bedroom without regard for the size of the unit or the configuration of the unit or the provisions in the local occupancy code that are generally based on the size and configuration of the unit, and that usually should dictate how many people would be allowed to live in a unit. So that's one area where we see complaints of discrimination involving familial status. The other is restrictions on where minors can go on a property and during what hours and whether or not adult supervision is required. So pool rules, it's a good time of year for it. Pool rules is one area where we've seen fair housing complaints. If a housing provider has a pool rule that requires anyone under the age of 18 that they must have a adult supervision, that would be an overly broad policy that is not narrowly tailored for health and safety reasons, right? Because you have 16-year-olds who can be lifeguards, right? And so a more narrowly tailored rule would require adult supervision for children under the age of 14. That would not necessarily raise fair housing concerns, whereas an under 18 rule would raise fair housing concerns. The final category under the Federal Fair Housing Act, and it's where we'll spend a lot of time today, has to do with protections for people with disabilities, both their affirmative right to ask for reasonable accommodations and modifications, as well as the general prohibition against discrimination against people with disabilities. Final category is under our State Fair Housing Act only, and it has to do with the development and siting of affordable housing, which was the focus of our training this morning. So there are 7 protected classes under the Federal Fair Housing Act: race, color, national origin, religion, sex, familial status, and disability. The term in the statute is handicap, but we will use disability as that's the generally accepted term. So what conduct is prohibited? Well, refusing to rent or sell or to negotiate for housing, discriminating in the terms or conditions and privileges, requiring additional security deposits, or not offering specials or requiring additional fees for protected class members. Misrepresenting the availability. Oh, shucks, that unit was just rented when it was actually still available, can constitute a form of housing discrimination. So the Fair Housing Act prohibits discriminatory conduct, but it also prohibits discriminatory statements, right? And so the housing provider that told my client who was trying to add a person with a disability to her household, when that landlord said, my apartment complex is not a mental institution, right, that's a discriminatory statement. The actions of then denying her request to add a person with a disability to her household is a discriminatory denial of housing. And so there are different sections of the Fair Housing Act that can all be violated during one housing transaction. Coercion, intimidation, threats, interfering with someone's right to fair housing can be a separate violation of the Fair Housing Act. If someone exercises their fair housing rights and the landlord turns around and seeks to evict them, right, that could constitute retaliation in violation of the fair housing laws. Harassment, I mentioned it earlier, it could be based on any protected class. So we've talked race harassment, sex harassment, but it can be on any protected class. And then there's this category of otherwise making housing unavailable, right? And so it's just a broadly interpreted statute, and it could cover other types of conduct that are not explicitly listed here that make housing unavailable. The Fair Housing Act prohibits intentional discrimination, but it also prohibits seemingly neutral policies that disproportionately deny equal housing opportunities to people in a protected class. And we'll talk a lot more about that today. And then refusing to grant reasonable accommodations and modifications for people with disabilities. In North Carolina, over the past 20 or so years, there was from like 2000 to 2010-ish, the most common type of complaint that had been filed in the state alleged race discrimination. Over the past 10 years, we've seen disability take over the top spot for fair housing complaints filed with HUD. This does not include cases filed in court. This is just HUD complaints. And we are seeing, since the pandemic, an increase in race discrimination complaints. All right, so fair housing protections for people with disabilities. And so when we start with this section, we start with, well, what is the definition of a disability? And it is a physical or mental impairment that substantially limits one or more major life activities. And it's like falling asleep, because what are we saying, right? So notice there's no diagnosis on that list, right? It's not about particular medical conditions. It's about limitations to daily life activities: walking, seeing, hearing, interacting with others, regulating emotions, learning, right? It is very broad, and it focuses on a person's daily living activities, not on a diagnosis. It includes people who have a history of having a disability, people who are perceived as having a disability. Maybe there is no official diagnosis, but the housing provider believes somebody has a disability. They would be protected under the Fair Housing Act. It also includes people who are residing in the unit. So if there are parents that have a child with a disability, the child's protected as well as the parents, and either can exercise the parents can certainly exercise their fair housing rights, their individual rights, as well as they could on behalf of the child's. So visual impairments, auditory impairments, mobility impairments, mental illness, cognitive disabilities, AIDS and HIV positive or disabilities under the Fair Housing Act, alcoholism, that includes current alcohol use, can be a disability under the Fair Housing Act. Former drug abuse. Current use of illegal drugs is not a disability under the Fair Housing Act. Former drug use, when someone has gone through a rehabilitation program, is a protected disability. So if somebody went through a rehabilitation program and that's going to show on where they were living and their rental history, right, and the housing provider knows that it is a substance abuse facility that they were residing in, and they deny the housing because of that, that could be a form of discrimination. So the Fair Housing Act prohibits discrimination based on disability, right? You can't deny housing to someone because of disability. You can't charge an extra fee because they use a wheelchair or because a person has some disability or they have a child with a disability. Housing providers cannot generally ask questions about the nature, existence, or characteristics of a disability. Now, there is a limited exception for when someone is trying to determine eligibility for a specific housing program. So like HOPWA is housing opportunities for people with AIDS, or the Shelter Plus Care program is specific for people that were unhoused and with mental disabilities. And so there can be a limited, narrow question asked by a housing provider to determine eligibility for a program. But beyond that, generally, inquiries into the nature or existence of a person's disability is prohibited. The other area where this will come up and certain limited information can be requested is when somebody requests a reasonable accommodation. And so I mentioned earlier, the Fair Housing Act prohibits discriminatory statements. Have you ever been in a drug rehab program would be an unlawful inquiry into the nature of someone's disability, right? Can you live independently? Independent living requirements are unlawful under the Fair Housing Act. So far we've talked about, and I think when a lot of people think about fair housing and housing discrimination, we talk about treating people equally, right? Like we treat everybody the same, then we're good. But that's not how the Fair Housing Act works. And when Congress amended the Fair Housing Act to prohibit disability discrimination, it affirmatively recognized that housing providers have an obligation to do more to ensure that people with disabilities can use and enjoy their housing. And it required housing providers to grant reasonable accommodations for people with disabilities. These are changes in rules and policies so people can live in their housing. It also requires that housing providers allow reasonable modifications. Those are physical changes to the structure so someone can live in their housing. And so, but why? Why did it require this? Because sometimes when we treat everybody the same, people with disabilities are still excluded from housing. And so if a leasing office has 3 steps to get up into that leasing office, everybody's treated the same. Everybody has to traverse the 3 steps. But someone who uses a wheelchair may never even be able to get into that apartment building to find out if there are even units available, right? And so that's why the law requires affirmative actions by housing providers to ensure that people with disabilities can access housing. So a reasonable accommodation is a change to a rule or a policy that's necessary because of a person's disability. Now, a reasonable accommodation could be requested at any time during a tenancy. It can be requested during the application stage. Maybe a tenant with a cognitive disability needs assistance completing the application, or maybe they have a mobility impairment and they know that when they move in, they're going to need a reserved parking space close to the entrance of their unit. They can request that accommodation when they move in. Maybe they're living in the unit and they realize the parking situation is too difficult for me. It's a first come, first served parking. The spaces close to the entrance of my unit are always full. I am either trapped in my unit or I am forced to park at the back of the lot, and I am not able to walk that distance because of my disability. That walk for a able-bodied person is very different than for a person with a disability. And so when somebody's living in that unit, they can request a reasonable accommodation, for example, a reserved accessible parking space close to the entrance of their unit. The other time when you can request a reasonable accommodation is during the eviction process. Even when you are in court and you are before the judge, you can request a reasonable accommodation. A reasonable accommodation can be requested and should be granted up until that final writ of possession is executed. A reasonable accommodation can be requested by the tenant themselves, a family member, an advocate, a social worker, a trusted family member or friend working on behalf of and with a person with a disability with their consent to submit an accommodation request. You've probably realized that an accommodation request it's broad. It's going to depend on the individual, their individual disability, the individual property, and what is actually needed. These are just some examples. I mentioned first come, first served parking. If a tenant must complete, if a housing provider has a requirement that the tenant has to come in to complete the application, and a tenant with a cognitive disability needs assistance, they need to be able to take that application home with them and get someone to help them complete it. They should be allowed to do that as a reasonable accommodation. Oftentimes we see rent is due on the first of the month, right? It's a pretty common policy that housing providers have. But someone who receives disability benefits as their primary source of income, they don't have control over when they receive those benefits. And the government generally sends them on the third Wednesday of every month. And so if you get your check on the 17th of the month and your rent was due on the 1st, you are constantly accruing late fees. And so as a reasonable accommodation, you ask to move your rent due date to coincide with when you receive your disability benefits. There was a case in Pennsylvania brought on this issue against a large housing provider, and there were 3 separate court decisions that all confirmed the same thing, that housing providers do need to consider reasonable accommodation requests to move a rent due date to coincide with disability benefit payments. Rent must be paid by check. You must drop it off in person. Maybe somebody needs a representative payee, or they need to be able to set up a direct debit method because of their disability. Maybe they're forgetting to pay rent on time, or there's a disability-related reason for it. If we can make that connection, it can be a reasonable accommodation request that someone can make. If there's a situation where someone needs to terminate their lease early because of their disability is worsening, they need to move in with family or an assisted living facility because of their disability, they should be able to terminate that lease without penalty. Housing providers cannot charge people for granting a reasonable accommodation. Occupants can only be, maybe the policy is occupants may only be added at the lease renewal, but there's a tenant with a disability who needs a live-in aid, right? And so they should be able to add the live-in aid to their household during the middle of a tenancy, even though the general policy is you would do it at lease renewal as an accommodation request for a person with a disability. Tenancy terminations due to poor housekeeping. There could be a variety of disability-related reasons why someone is having difficulty meeting the housekeeping requirements. It could be a physical disability, it could be a mental health disability. And so what can be requested is a reasonable accommodation for more time, to put a plan in place to allow that person to comply with the housekeeping requirements. Maybe they need a little bit more notice before the inspection takes place. Maybe they need an opportunity to get someone from an agency to provide some assistance, right? Maybe they need more time to cure any deficiencies, again, to get someone to come and help them because of their disability-related needs, right? And that is an accommodation request that should generally be granted. No pets allowed. That is a policy that we do see, but when that policy is there, if someone has a service or an assistance animal, they should be allowed to have that assistance animal despite the no pets policy. We get a lot of questions about assistance animals, and Hope's going to talk about them today. So reasonable modifications are physical changes to the property to ensure that a person with a disability can use their housing. And so this would include the common areas as well as the interior of the unit. Again, modifications, it's going to be very individual. Maybe it's a grab bar in the bathroom, or a wider doorway that's needed, or installing a wheelchair ramp to traverse a few steps to get into the entrance of the unit. Moving light switches and thermostats to accessible locations. Lever door handles instead of knobs can be easier for people with certain types of disabilities. The question we always get with reasonable modifications is who pays? And so in private housing, which generally includes low-income housing tax credit properties, as well as housing that's assisted with a tenant-based Section 8 voucher, That's generally private housing, and the tenant is going to have to pay for the modification. Now, there are resources and organizations that provide assistance to people who need these modifications, or sometimes Medicaid will pay or the VA will pay, and a person should be allowed to use these outside sources of funding, even if it's private housing, to make the modifications to their unit. In federally funded housing, which includes project-based Section 8 housing and public housing, Section 504 of the Rehabilitation Act requires that the housing provider make those modifications. The other caveat about who pays is whether or not the property should have been made accessible at the time of construction. And so there are design and construction requirements in the Fair Housing Act. So multifamily housing with 4 or more units built after 1991 has to have basic accessibility features. If the modification that a tenant is requesting is a feature that should have been made accessible at the time of construction, even in private housing, the housing provider should pay for the modification because it should have been done right to begin with. And so these are basic accessibility requirements, and it is really important that we enforce these provisions because once we build housing, it stays there for years and years and years. And so if we keep building inaccessible housing with an aging population, we are going to have a big problem. So the first requirement, and again, these are basic requirements, is that there is an accessible building on an accessible route, right? So these stairs to get to the ground floor units are not accessible. And so this would be a violation of the Fair Housing Act's design and construction requirements. The second requirement is accessible and usable public and common use areas. So the stairs you see there, those are the stairs to get to the leasing office. It's the only way to find out about available units. How is a person with a mobility impairment supposed to find out about units? They can't even enter the office. Doors, usable doors. So you see the red circle is highlighting a handle instead of a knob, right? Different disabilities. There's also what we call latch side clearance. There has to be a flat level surface next to the door so someone in a wheelchair can come up to that door, open it, and enter. The fourth requirement is an accessible route into and through the unit, so you have to be able to get through the entire unit. Threshold, door thresholds is where we see a fair amount of violations, particularly when it's going out to like patios and decks, right? The fifth requirement is related to the location of light switches. They have to be a minimum of 15 inches off the ground, no higher than 48 inches, so a seated user in a wheelchair can access the environmental controls and the light switches. And then usable kitchens and bathrooms. These are not accessible kitchens and bathrooms. These are usable. The main key point is that you have an area, 30 by 48 area of clear floor space, so a person in a wheelchair can enter the bathroom and the kitchen and close the door behind you. If you see a appliance like a sink in the corner, it will almost always be in violation of the Fair Housing Act because there is not enough clear floor space for a person in a wheelchair to use that sink. Okay, I'm going to pass it over to Hope.
Thank you, Lauren. Hi, everyone. I'm Hope Williams, also with the Fair Housing Project. And so for the rest of our time here, we're going to talk a little bit more about some of the practical issues with making reasonable accommodation and modification requests. We're going to talk about assistance animals, which is something we get a lot of questions about. And then we're going to finish up talking about domestic violence and criminal background, which are also issues that we get a lot of questions about. So who can remind me what a reasonable accommodation is? Anyone? All right. Well, I will remind you. A reasonable accommodation is a request for a change in a policy or procedure that is necessary based on a disability and is needed so a person can have enjoyment, in equal enjoyment of their property. And true or false, a reasonable accommodation request always has to be in writing for the landlord to even consider it. False. Good job. So HUD has some guidance about reasonable accommodation requests, and the guidance says that it doesn't need to be in writing. And the goal is that we want people to be able to ask for things that they need based on their disability so they can, access their rights under the Fair Housing Act. And people don't always know all the ways to do that, the correct way to do that, the words to use. And you all are here at this training, and so you're gonna know the way to do it. But HUD guidance is clear, is that it doesn't have to be in writing. So if someone asks for one orally, that should trigger for the landlord, who's required to follow the Fair Housing Act, that they need to take steps to consider this request. But of course, we're lawyers, and we're like, writing, put everything in writing, because you want proof that things have been done, and it can also help to clarify what's being asked for. So a best practice is to make it in writing, to use, say that you're asking for a reasonable accommodation, use those words, because it does make it clear that you're asking and asserting your rights under the Fair Housing Act. You should, in some cases, also provide documentation from a medical provider to establish that this is related to your disability and that you have a disability. Now, HUD guidance makes it clear that if a person has an obvious disability, if they are using a walker and they come and ask for an accessible parking space, then the landlord should not be making them go get a letter from their doctor to prove that they have the visible mobility disability that they have. But a lot of times people have disabilities that are not obvious. You might have a mental disability that impedes your behavior, your ability to interact with others, or your memory. And that's not going to necessarily be obvious to your landlord why you need this and that it's connected to a disability. So in that circumstance, it is okay for the landlord to ask for more information to establish that you have met the requirements to get a reasonable accommodation, which is showing that you have a disability and that it's necessary for you to have the equal access of your housing. So interactive process, this is a term that also comes out of HUD guidance and is referenced in case law. And what it means is that the process of asking for an accommodation or a modification should be a conversation. And so a person might not check all the boxes to establish that they need an accommodation when they initially ask for it, but that doesn't mean the landlord can say, sorry, didn't prove your case, I don't have to do anything. That should start a conversation of the landlord asking for the additional information that they need, and the person can go out and get that. And sometimes there might be a situation where what the person is asking for is not reasonable. And we'll talk about what's not reasonable in a second, but the interactive process means let's find some middle ground where we can find an accommodation that is reasonable and that meets your disability-related needs. And some other helpful language from the HUD guidance is that housing providers should be aware that persons with disabilities typically have the most accurate knowledge regarding the functional limitations posed by their disability. And sometimes we see with modifications and with accommodations that landlords are like, they want to do something different that maybe is more convenient, or with modifications, maybe is more aesthetically pleasing than what the tenant is asking for, when what the tenant is asking for is based on their own knowledge about their disability. And HUD guidance reminds us that the person who's living that life and with their disability is in the best position to know what their functional capabilities are, and that should be respected. So just quickly, as a summary about asking for that reasonable accommodation, best practice, put it in writing and state, that you have a disability. You don't have to give a diagnosis, but explain you have a disability that impacts these functions in your life, your daily living in this way, and that you need this, and specifically say what you're asking for. And if you have a disability that's not obvious, then you should get some documentation. Usually a letter from your doctor should suffice, or any medical provider who's working with you, who's familiar with your condition and with your treatment. Provide that along with a request or as a follow-up once you get that process started. So landlords, like I've said, can ask as part of this interactive process. They can ask for additional information only if it's not obvious. And they can also ask for additional information to show that what you are asking for is necessary and not just something that would be a convenience. So like I said earlier, sometimes a reasonable accommodation might not be reasonable. And the HUD guidance has spelled that out in more detail and saying that if something is a fundamental alteration in the services that a landlord provides, then that might not be reasonable. So an example of that is a person who has mobility limitations and can't drive ask the landlord to provide transportation services to the grocery store so they can get food. Well, landlords are not in the business of providing transportation. That's asking the landlord to do something that is entirely separate from the services that a landlord provides. That would be a fundamental alteration in the services. We don't encounter a lot of situations where people are asking for fundamental alteration services as part of a reasonable accommodation, but what we do encounter more is the other piece that HUD has said could be unreasonable, and that is if what the person is asking for creates an undue financial and administrative burden on the landlord. And so that usually means it's going to be something that's going to be pretty expensive for the landlord to be able to do. So an example of that is a person with mobility limitations can't take the trash out. And so they ask that the landlord send the maintenance staff over to their apartment every couple of days to take their trash out to the outdoor bin. And that's gonna, this is a small landlord, they don't have staff on site all the time. That would probably be undue burden because that's asking the staff person to take on extra work, maybe come in days that they're not there, and physically take the trash out. So that's creating an administrative burden, maybe a financial burden. You might have to pay this person more because they're coming in more. So that is something that would be an undue burden. However, again, let's go back to the interactive process. That shouldn't end the story. What the person asked for, maybe not reasonable, but maybe there's another solution that is. Maybe you can put a trash can closer to that person's unit where he can take the trash and dump it out, and then once a week when the maintenance staff comes in, they can take that trash can. So it's about finding that common ground and being reasonable, something reasonable that allows a person to be able to have equal access and to be housed. A lot of times we're just trying to keep people housed and finding out how we can overcome these disability-related barriers. So here's a quick example of a situation. This person's rental application has been denied because her landlord refused to give her a good reference, saying she always paid rent late, like Lauren said earlier. Sometimes a person might be paying their rent late because of the timing of their disability checks, and now she's getting a bad reference because they're saying you always paid your rent late, and so you're not going to be a good tenant. So, and this is disability related, and it's, she now has maybe lost her previous housing and is about to not qualify for new housing. So an accommodation she might request is, as part of this process, asking them to disregard their policy about considering the reference of the former landlord because there's a reason and an explanation that's disability related, and asking for that accommodation to have her rent date reflect when she gets her payment so she's not late. It's not that she doesn't want to pay rent. She's not an irresponsible tenant. She has a disability-related reason for doing it. And you see here we have a sample letter. It's just a very simple, straightforward request. You explain your situation, you explain what you're asking for, and in this situation, she probably doesn't need a letter from her doctor. She might just need proof that she's getting this SSI and the date that she's getting it. So this is how you would make that simple request. It doesn't have to be fancy. It doesn't have to have a lot of legal language in it. So sometimes a landlord does not have to grant a reasonable accommodation or allow a person to reside in a place if that person creates a direct threat to the health and safety of others or would result in substantial damage to the property of others. So this is a situation where a person's behavior might create, a dangerous situation. But HUD is very careful about this in their language, and they say, this isn't a blanket opportunity to say, we don't have to rent to you because you have a disability and you might create a threat. It has to be, first of all, based on an individualized assessment of that person and that person's history. It can't be based on stereotypes about types of disabilities. And it should only, a person should only be excluded if there has been an opportunity to determine, is there a reasonable accommodation that would eliminate that threat? And there's some pretty dramatic case law out there where people have engaged in some pretty surprising behavior, and courts have found that the landlord was wrong in not allowing that person to continue to live there because the tenant established that they were following a course of action to make sure that that behavior didn't happen again. And that's a reasonable accommodation because, sometimes people are not, they don't know their diagnosis, they're not getting treatment, they're not following their treatment, they're not getting the help and the support that they need. And, the whole goal here is to allow people with disabilities to have equal access to housing. And if there's something that can be done that the tenant is going to follow, then that is going to allow them to overcome that incident. For example, like in one of these cases, somebody was watching a documentary about genocide and had a mental breakdown and thought that his wife was trying to harm him and had a gun, and he hit her, and he went outside and was waving a gun. But then he got help, and he was getting treatment, and he had a caseworker who was working with him, and the landlord said, no, we don't have to rent to him because that incident that happened a month ago. But the court said, no, there is a reasonable accommodation that could address this, and it is discrimination against this person with a disability who has taken these steps to be able to live here safely and not be a threat to anyone, and that is a violation of the Fair Housing Act. So a few other things when you're working with people, and we often are working with people who are seeking reasonable accommodations, is something that people have to follow through. So you have to be able to be in a position to take the steps that you're saying you're going to take to get the reasonable accommodation that you're asking for. Because what we're trying to help is people follow the rules, the reasonable expectations of them. Are there people that can be a support person? In the case I mentioned, this person had a caseworker who was on hand in case this person, to help him track his medication, to make sure if something happened that he had trusted people to talk to. The goal is to have a plan that will be successful and to allow the person to comply with the lease. So, assistance animals. This is always a big question that we get. So we like to talk about it because there's a lot of misunderstanding about assistance animals. And so first of all, I just want to point you to, HUD has put out some super helpful guidance about assistance animals, and it really goes through all the questions that we get. Those questions are answered in the HUD guidance about assistance animals. We have it on our website, it's on the HUD website, and it's in a question-answer format. It's designed for people who need assistance animals, it's designed for landlords, it's really to answer these questions, but we're summarizing it here because it is something that comes up a lot. So, landlords can have any rules that they want about pets. They can have no pets, they can have breed restrictions, they can have size restrictions, they can charge pet deposits, they can charge pet rent. A landlord can have any rules that they want about pets, but service animals and assistance animals are not pets. They are like a piece of assistive equipment that a person has been prescribed to have because of their disability. So they are a separate thing from a pet. So pet rules should not be applied to an assistance animal. However, assistance animal and service animal owners are responsible for their assistance animal. They just cannot be charged fees, and rules that are in place about pets, like size restrictions, breed restrictions, are not going to apply to assistance animals and service animals. Quickly, the difference between a service animal and what we call an assistance animal. A service animal is either a dog or a miniature horse that has been individually trained to perform a specific task for the benefit of the person with a disability. And so when you are out in the world and you see service animals allowed, that is this type of animal, a dog, a miniature horse that has been trained to do a very specific task for a person with a disability. When you're at an apartment complex, a service animal can be in any of the places that are open to the public, like the leasing office and so on. So those are service animals. It's a pretty limited category of animals, and the definition comes from the Americans with Disabilities Act, which addresses public accommodations, and so that's where that definition comes from, and that wider access to have service animals in those spaces. Assistance animals are animals that they could be a non-dog or miniature horse that performs a task, or they could be animals that provide other therapeutic or other emotional support services to persons with disabilities. They don't have to be trained. It could be that the person has the ownership and care of that animal, has a therapeutic benefit, and they have to be animals that are typically kept in households like cats, dogs, birds, gerbils, so on. And so these animals are protected under the Fair Housing Act along with service animals. So like I said earlier, if it's an assistance animal, you can't charge fees up front, breed restrictions shouldn't apply, size restrictions shouldn't apply, and the person does have to establish that they're necessary because of the disability. Now, as I said, typically an assistance animal needs to be a household animal. There are some circumstances where people have demonstrated that they have a disability-related need to have a unique assistance animal. For example, there was a person who was paralyzed and had a monkey that was trained to bring stuff to him, which a dog or a cat couldn't do because they don't have opposable thumbs. And so that was a circumstance where he was able to establish that he had a disability-related need for this unique animal. We've also had some cases where people have established a disability-related need for chickens because they're not getting a therapeutic benefit from a cat or dog. Maybe it's stressful having the cat or dog, or maybe they have allergies, but they maybe grew up raising chickens when they were young, and that chicken has a therapeutic benefit. So maybe there's a rule at their homeowners association that you can't have chickens, and they need an exception for that. But it is a higher burden to show that you need these unique animals. So you have to show why a typical household animal would not be sufficient to address your disability-related needs. So sometimes we get questions, well, it sounds like people with assistance animals can just do whatever they want. That's not true. They're still responsible for their animal. They have to keep the animal under control. If the animal damages anything, they have to pay for that, as long as it's anything beyond normal wear and tear in the landlord-tenant situation. They have to pick up after the animal. So the owner still has responsibilities to manage their assistance or service animal. They just can't be charged things up front or subjected to rules that are applied to pets. Internet documentation, we got a question about this morning at an earlier session we did. So unfortunately, there are some services out there where people can pay a fee to have some documentation provided that says, this is an assistance animal or this is a service animal, when there's not an actual medical provider who is confirming that. And HUD guidance has said that that documentation on its own is not sufficient to establish a disability-related need for this animal, and that in that circumstance. And we've had people who have had that documentation. I had a client who thought that that's what he needed to get. His doctor had prescribed him the assistance animal, but he thought he had to get this documentation, and that's what he turned into the landlord. And so then we were able to get the actual documentation from his real doctor. And unfortunately, sometimes people pay hundreds of dollars for this documentation, and it's simply not reliable because it's not somebody who has a real knowledge of the person's disability. So we have people get something from the person or the doctor who's treating them as support that they need the assistance animal, and that's in line with HUD guidance. Multiple assistance animals. Can you have more than one? Well, that depends. So sometimes people have the need for more than one animal because they have different disability-related needs. Maybe they have a service animal that provides them with mobility support, like a guide dog. And then they have an assistance cat that is acting as a comfort animal to them. So if they can establish an independent need for each animal, then they should be able to have more than one assistance animal. But they do need to prove the disability-related need for each of those animals. Sometimes we have people who have more than one person with a disability in their household. So in that case, there might be more than one animal. But again, you have to prove the disability-related need for each of those animals. All right, so we're going to switch gears and just talk briefly about domestic violence protections under the Fair Housing Act. And we just want to talk about, there's several layers of domestic violence protections when we're talking about housing. And this is such an important protection because I used to work in the area of domestic violence, and so many times I would have clients who were at risk of losing housing because of the domestic violence that they were experiencing. And the state of North Carolina and the federal government have all recognized this, and there are laws and protections in place to try to prevent this from happening to this vulnerable population. So starting with North Carolina landlord-tenant law, in Chapter 42 of the North Carolina General Statutes, there are a few specific protections for persons who are survivors of domestic violence. So landlords can't terminate a person's lease because of domestic violence. They can't fail to renew a lease because of domestic violence. They can't evict them because of domestic violence, or retaliate in other ways. And sometimes this is a really strong and immediate protection if we're working with someone who is facing eviction and we learn that there's domestic violence involved. Maybe property was damaged, or police were called, or some sort of fight happened in their house and they're being evicted because of the criminal activity that's being alleged. So this is a protection under the state law and can be a defense that can be raised in an eviction case. There also are some protections if someone needs to terminate their lease early. So usually when you have a lease, it's for a year, and if you terminate your lease early, you can have to pay a penalty. You might have to keep paying rent until they can re-rent the property. And so it can be a hardship, and sometimes that's why people don't leave domestic violence situations, because they're trapped. They don't have the money to pay 2 rents because they can't get out of their current lease, where the abusive person knows where they are and is coming to their house. So there's an early lease termination provision in North Carolina law that allows people to, if they can establish that they have a protective order and that they are working with a local domestic violence agency, they should be able to terminate their lease early without a penalty. They have to give 30 days notice, and they are not responsible for any rent beyond the time they move out. Now, if they were living with the abuser can be liable for the rent for the rest of the period. So these are some really important protections that we have under state law. With subsidized housing, there are some other federal protections. So subsidized housing is, public housing, Section 8 vouchers, housing choice vouchers. So if tax credit properties, so it's different affordable housing programs and subsidized housing programs. Because of this federal funding that's involved, the federal government can put some some rules that apply to this housing. And so some of those rules are under the Violence Against Women Act, and it provides some similar safeguards as we have in the North Carolina law, but it also applies to somebody not losing their subsidy. Sometimes that voucher that you have is, your ability to be able to live somewhere affordably, and you lose it or you're getting evicted because of domestic violence. And sometimes if you get evicted, that also means that you're somehow in violation of your voucher rules. And so you can have this protection under VAWA to establish that you should not be evicted or lose your subsidy because of domestic violence. And the documentation rules under VAWA are even a little more flexible even than the North Carolina law. You can write up a statement that explains your situation. You can have something from a mental health provider. Of course, court records can be helpful, but sometimes people don't have a protective order or aren't able to get one, or sometimes there's barriers to getting one. And so this broader array of documentation that is considered can be helpful. And the Violence Against Women Act was amended recently to even expand protections further. Something that's important is that it's the Violence Against Women Act, but it applies to anyone who's a survivor of domestic violence or sexual assault. So there are men who are victims of domestic violence, and they would be protected under the Violence Against Women Act as well. So earlier when we're talking about fair housing, bringing this back to the fair housing, so fair housing law, the Fair Housing Act protects people based on protected classes. And Lauren went through the list of protected classes, and that list does not include survivors of domestic violence. So the way the link with domestic violence protections under the Fair Housing Act is because, as Lauren said earlier, domestic violence are predominantly women, and statistically, you can look up this data in North Carolina. Of 154 calls about domestic violence, 83% were female, and 17% are male. And you can look up this data on a county-by-county basis, and nationally, this data is the same. That is 85% nationally, survivors and victims of domestic violence are going to be women. And so because of this, when landlords take actions or have policies or rules that impact survivors of domestic violence, make housing unavailable to them, make it more likely that they're going to be evicted for certain things that happen that are related to the domestic violence, that burden is falling disproportionately on women. And because of that, that can make it a violation of the Fair Housing Act. So this is another layer of protection under federal law that is out there for survivors of domestic violence. So some examples are landlords terminating leases because of domestic violence incidents, or subsidies because of property damage. We see that a lot. Property damage, doors get damaged, windows get broken by a person who is assaulting a partner, and the partner is kicked out of the house because it's against the lease to damage the property in that way. And then sometimes that follows them down the road. They're trying to get new housing, and usually landlords are calling previous landlords, and the previous landlord says, yeah, we kicked her out because she broke windows got broken, and so that next landlord doesn't rent to her. So, and then 911 calls. Sometimes that's considered a violation of the lease, because if you're calling 911 enough, that means that there's criminal activity happening in your apartment. And if those 911 calls are about domestic violence, and there's statistics that show a high percentage of 911 calls to residences are domestic violence, that policy can fall disproportionately on victims of domestic violence who are women. Sometimes there's overlap with disability, bringing it back to what we were talking about earlier with disability. They're more likely to experience physical injuries that can cause disability and mental health disabilities that can cause disability. That can count as a disability. All right, very quickly, because I want time for questions. Criminal background. This is something that comes up a lot, and HUD has also issued guidance similar with domestic violence, where that disproportionately impacts women. HUD has cited extensive data that shows that our criminal justice system disproportionately impacts people of color and people of different national origins. And because of that, if landlords have overly broad policies about criminal background, then that is disproportionately going to fall on people who are part of those protected classes. And so HUD has said that landlords need to have policies that are tailored. They shouldn't be broad, saying anybody with a criminal record can't rent here. They say they shouldn't have policies that anybody with an arrest can't rent here. They should have tailored policies that look at the nature of the offense, the severity of the offense, how much time has passed, what the person has done in the meantime since that offense or since that conviction. And very importantly, HUD has reinforced over and over, and even in some additional guidance that came out within the last few weeks, that landlords should be allowing for individualized assessments, meaning don't just look at that criminal background report that gets printed out by this other company. You need to understand that person who is in front of you, because because what you're trying to figure out is this person going to be a good tenant? Are they going to pay their rent? Are they going to follow the rules? And somebody having some record from many years ago who has paid their dues to society, has been working, doing other things, that person, the fact that they have this conviction doesn't mean that they're not going to be a good tenant. And having rules where you're automatically excluding people based on criminal background is likely to be a violation of the Fair Housing Act. And HUD says really the best way to address this is have individualized assessment. And just a word about, and so what is individualized assessment? Providing additional information about your circumstances, maybe letters of reference, letters from former landlords. Sometimes people rent, from a landlord who's, there's maybe the data is not online through these background reports. So having that information can be helpful. Proof that you've been working, if you've been in a rehab program, something showing that you've taken these steps to get back on track. And it's helpful to get all that together before you apply for housing. So if you are denied, you can have that information quickly available to provide. And on that note, we have just finished and are about to post a guide for people who are renting with a criminal background with some guidance and a sample letter you can use to request that individualized review. So that's going to be on our website, and so be on the lookout. We should have it up within the next week or so. And just a quick word about third-party screening companies. They are companies that landlords contract with to do the background reports. Sometimes there's errors in the information, and HUD has also issued guidance recently about how these companies can lead landlords to not comply with the Fair Housing Act because of over-reliance on these reports, and that there are some actions that these third-party companies perhaps should be taking to make sure that they are not reporting information that is contributing to discrimination. I want to give time for questions, so I'm going to just open it up for questions now. Thank you all. So I think people are being asked to come over here to ask questions. And the evaluation, is that yes. And we also have an evaluation. It looks like it's being passed out. So we appreciate it if you could fill it out. We're always looking for ways to improve our presentations. And of course, want to hear feedback from you.
So please come on over with your questions. You're welcome to line up here.
Oh. Well, they want people to do it in the microphone, so because we're recording and they want to be able to hear the question. Yes, thank you. Go ahead.
I had a question if the Fair Housing Act has any guidelines that landlords have to follow with like simple home repairs that are like imperative to the structure of the house. Like say like I had a leaky roof and water was getting through to the house. Like, is there like a timeline the landlord has to like fix?
So that, there are laws about that. It's under Chapter 42 of the state landlord-tenant law. And there's also, often there are local municipal ordinances about that. But basically under landlord-tenant law, landlords are required to provide a habitable place and to do repairs in a timely and reasonable manner. And so you should make your request in writing for sure if you have a need for repairs. That's a little bit outside of our expertise because we focus on fair housing, but there are rights. And that is something that Legal Aid handles, our general legal aid team. So you could call, we have information outside with our contact information. But yes, that's a landlord-tenant issue.
Yeah, generally it'll fall under the landlord-tenant laws. The only area where we might see some fair housing is if repairs are being done for certain tenants and not others based on a protected class. So if repairs for white tenants are being done faster and better than the repairs for black tenants, that could be potentially a difference in treatment under the Fair Housing Act. But generally those types of claims fall under the landlord-tenant laws.
Okay, thank you.
Sure, thanks for the question.
Hey, does emotional support animal fall under the assistance service animal? Okay,
Yes.
I thought so. So second part, I've had a couple of physicians say no to writing that letter. Most of our veterans, not most of them, but some of our veterans that I've worked with are already diagnosed with like anxiety and depression. So I would call and say, can we get a letter for this? Like this, he's been with this dog forever, and they'll say no. So do you have any like suggestions on?
So it doesn't have to be a VA doctor that signs this letter.
Yes, I've done like community clinics too.
Okay, so you want someone who, with knowledge of the person to write the letter, and there is, in the guidance from HUD in 2020, it'll tell you the different types of people who are qualified to write that letter, but it does not necessarily have to be an MD, if that makes sense.
So it could be like a therapist or like a...
Yes, absolutely, a psychiatrist, a therapist, a social worker.
Okay, and so the form that some folks get online that they pay the money for, if you had like a diagnosis plus that form and put those together, would that be equal for like the legal documentation that you needed, or do you have to have?
You generally want a letter, some sort of document from a treating provider with knowledge of the person's disability and disability-related needs. What happens with those it could be telehealth, but what happens with those like online things is that there oftentimes is not that ongoing relationship, and that's why that alone is not enough.
Gotcha. Thank you.
Yeah.
And just,
Yeah.
I mean, if people are being denied a reasonable accommodation, they can call legal aid or other experts. It might be helpful to talk to a fair housing person, refer them to legal aid, and so we could look at this situation. Because we have heard about certain doctors who just don't want to get involved, and they don't want to sign letters because they think they might be bringing some sort of like bringing themselves into a legal issue, and they just don't really understand or know what it's all about. So, yeah.
Hey, I have kind of a two-part question. The first one was about, so are there provisions in place or any sort of protections for like a community housing project that's specifically for a protected class? Like, I'm kind of thinking bad faith actors coming through, and like if there was a, say, transgender support community place that was for transgender folks, and then bad faith actor comes through and tries to claim that they're not being fairly housed. Is there anything along those lines?
I want to make sure I understand the question. It's a housing community for members of a protected class, or it's just
Yes.
a housing community where members of a protected class live?
Like a protected, or a specifically set up for a protected class.
Yeah, I would speak with some, I think that's a little bit beyond of what we're going to be able to cover here. I think you're going to want to speak either with us separately afterwards, and we can probably direct you to someone to talk more about that.
Alrighty. And the other one is just following up on the resources for funding for reasonable accommodations. You said Medicaid and the VA. Are there any more?
Independent
general-
living centers will sometimes help, and I know there are some organizations actually out here in the mountains that help. I'm sorry? Yeah, Voc Rehab will also do it. There's a group out here, the Mountain Men. There are some other, I think, nonprofits out here that will help.
Gotcha. Do you know where I could find any directory or resources?
Well, yes. Our local resource.
Thanks, y'all.
Yeah.
I'll also say in general, people can contact their council on local council on aging, and they often know about resources in their counties, especially when I'm talking to somebody who's in a more remote place that it's hard to figure out what's out there.
Hi, I just have a quick question, and I'm going to put a little bit of the scenario here just because it's a little bit complex. But let's say a property is sold to a new person, that they have housing assistant tenants. The new landlord is trying to do reasonable accommodations for this particular tenant that is through the assisted living. Will the assisted living be able to give us, or the new landlord, like a diagnosis for this person for us to do reasonable accommodations for that tenant, since we're new to the landlord and we don't know the history behind it? Or how will we go by that?
I mean, I would think that if a new landlord does not have the proof that the person needs that accommodation, that it's part of that interactive process to ask if they can just get copies of that documentation. If the tenant file was not passed from the previous landlord, but if sometimes there'll be a tenant file that gets passed from one landlord to the next that already has that information.
Okay, so that if that information is not passed to the new landlord, and the housing assistant is saying, for privacy, HIPAA regulations, we cannot give you this information, how could we handle that situation?
I'm not sure.
mean,
I'm not. Maybe this might be better to speak offline because I'm not sure I'm following the situation. Because usually someone's requesting an accommodation on behalf of and with the permission of the person with a disability. And so if you're not working with that person, I'm not sure how you would go about requesting an accommodation.
Right, I'm just thinking on the legal side, how will that affect the new landlord and the tenant if we cannot, if you cannot accommodate the tenant because you don't know the history behind.
Right, and then I think it is on the tenant to explain to the new landlord what the accommodation that they had and what they need, and showing what was previously provided.
Okay.
That's why when we say the HUD does not require the magic words or that it be in writing, we recommend it. You keep a copy for yourself, so you have records. So those types of situations, when that happens, you have them ready to go, right? Like this was the information that we gave to the prior landlord and it was granted. Now, if that new landlord is denying the accommodation, then you can call either the Fair Housing Project or someone else for assistance to find out what other options there are beyond that.
Right, and landlords should not be asking for diagnoses. The letter from the doctor just needs to say this person has a disability and this is how it impacts their daily life functions. and this is why they need the reasonable accommodation. So, that diagnosis is confidential, and sometimes a person is fine sharing their diagnosis, but that's for the person with a diagnosis to decide for themselves, and landlords should not be asking or requiring that information as part of the
But they
reasonable
should at least
accommodation.
provide a letter with the
Yeah.
recommendation of the accommodations.
Yes, if it's not obvious. Why they
Thank
need
you.
to do it. Yeah, thanks for the question. Any other questions?
Hello, I'm from Buncombe County's Communication Department. I'm Angelica Tyler. We've had some questions about the slide deck and today's recording. So the site where you registered for today's event, engage.buncombecounty.org, you'll find fair housing training events. On that same site, you can subscribe, or if you registered, we already have your email. I'm going to send out an email blast as soon as the video is ready and the slide deck from today, from both the morning session if you missed it and this afternoon session if you want to share it or review it. So those things will be available, and I also have a plan to kind of send out some email blasts when the criminal justice forum goes live and any other events like the Spanish language event we plan to host in the fall. So I really encourage you to subscribe to that page because all of our updates and upcoming events will be on that same site. And it's a great way to kind of be the first to know when those things come back out.
Thank you.
Thank you all so much for
Thank
being
you
here
all.
today.